Imagine two sisters, standing in their childhood kitchen 3 days after their father's funeral, going through a shoebox of papers because nobody can find a will. One sister is certain their father wanted the house to go to her because he told her so, once, years ago, over coffee. The other sister has a different memory of a different conversation. There's no document, there's no witness, there's just two grieving women, a shoebox, and the slow, quiet start of a fight that will outlast the grief, and in some families, outlast the relationship itself. This happens more often than you'd think, not because families don't love each other, not because parents didn't care. It happens because of a handful of very ordinary, very avoidable mistakes that quietly work their way into almost every estate plan, or into the complete absence of one. Before we go any further, I want to be upfront with you about something. I'm not an attorney, and I'm not a financial advisor. What you're about to hear is general education based on how these things typically work in the United States. Estate law is different in every single state, and sometimes it's different in surprising ways, so nothing here should be treated as instructions for your specific situation. Think of this as the conversation you wish someone had sat you down and had with you years ago, before you needed it, so that when you do sit down with a licensed estate planning attorney, you already understand the landscape and you know what questions to ask. Here's why this matters right now, today, whether you're 62 or 48 or 75. Estate planning mistakes don't usually show up while you're alive to fix them. They show up afterward, when you're not in the room anymore, and the people who loved you are left holding the pieces. A will that was never updated, an account that still lists an ex-spouse as beneficiary, a house that was never retitled the way everyone assumed it was. These aren't dramatic, headline-grabbing failures. They're small oversights that sit quietly for years, sometimes decades, until the one moment when it matters most, and by then, it's too late to fix them. So here's what we're going to do together over the next few minutes. I'm going to walk you through the 5 estate planning mistakes that time and again are the ones that end up dividing families, draining inheritances, and turning what should have been a final act of love into a legal and emotional mess. These aren't rare mistakes made by careless people. They're common mistakes made by loving, responsible people who simply didn't know what they didn't know. By the end of this video, you'll understand exactly what they are, why they cause so much damage, and what questions to bring to a licensed attorney in your state, so your family never has to stand in a kitchen wondering what you really wanted. If any of this feels useful to you, consider subscribing because we cover one of these topics in depth every single week. And this is the kind of thing that's much easier to learn before you need it than after. Let's start with the mistake that causes more family breakdown than almost anything else: having no will at all, or having one that's dangerously out of date. It's easy to assume that if you don't have a will, everything just goes to your spouse, or gets divided evenly among your kids, the way it probably should. But that's not how it works. When someone dies without a valid will, state law decides who gets what through a set of rules called intestate succession. These rules don't know that you were estranged from one child and close with another. They don't know that your daughter took care of you for the last 5 years, while your son lived across the country and barely cooled. They don't account for the stepchild you raised as your own, but never formally adopted, who, under many state laws, may end up with nothing. Intestate succession is a formula, not a reflection of your relationships or your wishes, and formulas don't do nuance. And here's the part people miss. Having an old will can sometimes be almost as risky as having no will at all. Life changes, people remarry, people divorce, children are born, and sadly, sometimes children or spouses pass away before the person whose estate it is. A will written 20 years ago might still name an ex-spouse as executor. It might leave everything to a sibling who's no longer living, without any instructions for what happens next. It might completely leave out grandchildren who weren't even born when it was signed. An outdated will doesn't automatically update itself to reflect your current life. It sits there, frozen in time, until the day it's read aloud in a lawyer's office or a courtroom, and everyone in the room realizes it doesn't match reality anymore. At that point, updating it is no longer an option. The person who could have made the change is gone. This is closely connected to the second major mistake, which trips up even families who did everything else right: setting up a revocable living trust and then never actually funding it. This one catches people off guard because it feels so counterintuitive. Many people go through the process of creating a trust specifically to help their family avoid probate court, the sometimes long, sometimes expensive, and always public court process that otherwise handles the distribution of an estate. They pay an attorney, they sign the documents, they feel a sense of relief that the hard part is done. But a trust only protects the assets that have actually been retitled into its name. If your home is still deeded in your individual name, if your bank accounts are still titled the old way, if your investment accounts were never formally transferred, then as far as the law is concerned, those assets were never actually placed inside the trust. They're still yours, individually, sitting outside the protection you thought you'd built, and they will likely have to pass through probate anyway, the very process the trust was created to avoid. Consider a situation where a widower in his early 70s works with an attorney to set up a beautifully drafted, revocable living trust. He's proud of himself. He tells his adult children over Thanksgiving dinner that everything is handled, that they won't have to deal with probate court, that he's protected them from all of that. What he doesn't realize is that his attorney gave him a checklist for retitling his house, his brokerage account, and his savings account into the trust's name, and that checklist has been sitting in a drawer, unopened, for 3 years. When he passes away unexpectedly, his children discover that the trust itself is essentially an empty shell. The house is still in his name alone, the accounts never moved. Instead of the quiet, private transfer he promised them, his children end up in probate court anyway, paying legal fees on top of the fees he already paid to create a trust that never did its job. This isn't a rare story. Attorneys who work in this field see it constantly, and it's almost always because funding the trust felt like paperwork that could wait, and then there was no more time. Let's move to the third mistake, and this one might be the most surprising, because it has nothing to do with a will or a trust at all. It's outdated or missing beneficiary designations. Here's something a lot of people don't realize. Your will does not control everything you own. Accounts like your 401k, your IRA, most life insurance policies, and many annuities pass directly to whoever is named as the beneficiary on that specific account, regardless of what your will says. The beneficiary designation form you filled out when you opened the account, sometimes decades ago, legally overrides your will entirely. If you got divorced 15 years ago and never updated the beneficiary on your old 401k, your ex-spouse could still legally inherit that account, even if your current will leaves everything to your spouse and children. Even if everyone, including a judge, agrees that's clearly not what you would have wanted. The paperwork controls, not the intention. This mistake compounds quietly over a lifetime. People change jobs and roll over retirement accounts without reconfirming the beneficiaries. They open new life insurance policies during different chapters of life and forget about old ones. They get married, then divorced, then remarried, and somewhere in that timeline, a beneficiary form from 20 years ago never gets touched again. These forms feel unimportant precisely because they're boring. Nobody feels emotional filling out a beneficiary designation form at a new job orientation. But that boring, forgettable form can end up being the single most powerful document in your entire estate, more powerful than the carefully worded will you paid an attorney to draft. The fourth mistake is one people avoid thinking about because it isn't really about death at all. It's about the possibility of becoming unable to make decisions for yourself while you're still alive. This is the absence of an incapacity plan. No durable power of attorney, no healthcare directive, no clearly named healthcare proxy. We tend to think of estate planning purely in terms of what happens after we die, but a serious stroke, a car accident, an advancing diagnosis like dementia, Any of these can leave a person alive, but unable to manage their own finances or speak for their own medical care. Without the right documents in place, your family doesn't automatically get the authority to step in and help you, even if you're married, even if it's your own adult child standing at your hospital bedside. In many cases, your family would need to go to court and request what's called a guardianship or conservatorship, a process that can be slow, expensive, emotionally exhausting, and, because it involves a judge, entirely public. A durable power of attorney lets you choose, while you're of sound mind, exactly who should manage your finances if you become unable to. A healthcare directive, sometimes called a living will, lets you spell out your wishes about medical treatment, and a healthcare proxy names the specific person you trust to make those decisions if you can't communicate them yourself. Without these documents, families are often left guessing, sometimes disagreeing bitterly with each other about what their loved one would have wanted, all while that loved one is right there in the room, unable to settle the argument themselves. It's one of the most painful positions a family can be put in, and it's almost entirely preventable with a small handful of documents that most people put off because the topic feels uncomfortable. Which brings us to the fifth mistake, and in many ways it's the one that turns the other four from private oversights into public family conflict: failing to communicate the plan. You can have a flawless will, a perfectly funded trust, updated beneficiaries, and every incapacity document in place, and still leave your family blindsided if nobody knows any of it exists, or worse, if different people were told different things over the years. Consider a family where a mother, over the course of many years, tells one daughter privately that she'll be the one to inherit the family home, because she's the one who lives closest and helps most. Around the same time, in a separate conversation, she tells her son that everything will be split evenly because that's what feels fair to her in the moment. She means well in both conversations. She's simply speaking from the heart at different times, without realizing those two conversations are on a collision course. When she passes away, both children are holding on to a version of the truth they were told directly, by their own mother, and no document exists to settle which version is real. What follows isn't just a legal dispute over an estate, it's a wound in the relationship between siblings that in far too many families never fully heals. Silence around estate planning almost never comes from a lack of love. Usually, it comes from discomfort. Nobody wants to sit at the dinner table and talk about their own mortality. Parents worry that discussing the will makes it seem like they're playing favourites, or that it will spark jealousy among siblings before anyone has even died. So the conversation gets postponed, year after year, until it's not a conversation anymore, it's a surprise, delivered at the worst possible moment to people who are already grieving and least equipped to handle a shock. Now let's talk about some of the myths that keep otherwise careful people from avoiding these 5 mistakes in the first place. The first myth is that estate planning is only for wealthy people. This one is genuinely dangerous because it convinces middle-class families, the people who arguably need this protection the most, that none of this applies to them. If you own a home, have a retirement account, or have minor children who would need a guardian, you have an estate that needs a plan, regardless of your net worth. The second myth is that a will alone lets your family avoid probate court. In most states, a will actually has to go through probate to be legally executed. It's a trust, properly funded, that typically helps a family bypass that court process, not a will by itself. The third myth is that joint ownership solves everything. Adding an adult child's name directly onto your bank account or house deed as a joint owner can create real problems, including exposing that asset to your child's creditors, their divorce, or their own legal troubles, since as a joint owner, it becomes partly theirs immediately, not just after you pass away. And the fourth myth, maybe the most common one of all, is that your state's laws work the same way as your neighbour's state, or the state you saw discussed in an article online. Estate law, probate rules, and even the tax treatment of inherited assets vary meaningfully from state to state, which is exactly why a conversation with a licensed attorney in your own state matters so much more than general information ever can. So what can you actually do with all of this? Start by locating your current will, if you have one, and honestly asking yourself when it was last updated, and whether it still reflects your life as it is today, not as it was 10 or 20 years ago. If you have a trust, confirm in writing which specific assets have actually been retitled into that trust's name, because the trust document itself is not enough. Next, pull up the beneficiary designations on every retirement account, every life insurance policy, and every annuity you own, and compare those names against your current wishes, because those forms quietly override your will. After that, check whether you have a durable power of attorney and a healthcare directive in place, naming someone you trust to step in if you're ever unable to speak for yourself. And finally, and this might be the hardest step, but it's the one that prevents the most damage, have the conversation with your family. Let them know a plan exists. You don't have to disclose every dollar amount or every detail if that doesn't feel right to you, but let the people you love know that a plan is in place, where the documents can be found, and who to call. That single conversation can be the difference between a family that grieves together and a family that fractures. I know this isn't the easiest topic to sit with. Talking about wills, incapacity, and what happens after we're gone forces us to face things most of us would rather not think about on an ordinary afternoon. But here's the way I'd encourage you to look at it. Estate planning isn't really about death at all. It's about love, translated into paperwork. It's the last conversation you'll ever have with the people you care about, and unlike the conversations you have over dinner or on the phone, this one gets read exactly as written, with no room for misunderstanding, no memory to argue about, no shoebox full of uncertainty. Getting it right isn't about being wealthy or having a complicated life. It's about caring enough to remove the guesswork for the people you're going to leave behind. If this video helped you see a blind spot in your own plan, or in your parents' plan, that alone was worth the time. The next step is a conversation with a licensed estate planning attorney in your state, someone who can look at your specific accounts, your specific family, and your specific state's laws, and help you close these 5 gaps for good. And if you found this valuable, subscribe to Golden Wealth Report, because we publish a new video like this every week, walking through exactly these kinds of topics in plain English. Everything in this video is general education, not legal advice. Estate laws vary from state to state, so before you make any decisions, talk to a licensed estate planning attorney in your state. Take care of yourself, and take care of the people you love by making sure they never have to guess.